afternoon, everybody. My name is Nayette Castelline, and I am with the Sex Offender Management Unit for the Department of Corrections. So I am going to just kind of cover a little bit of that information as it relates to sex offenders and some of the hurdles they kind of face when they're coming to the community, whether it's parole or being placed on probation. So give me a second to share my screen here real quick. And for some reason, I can only see speakers. I can't see anybody else. So is everybody able to see my screen? Thanks, Miriam. All right, so really this is just going to be an overview of what it means to work with some of our sex offenders. I'm going to just cover a little bit as to how they get placed in the different tiers, because that's usually one of the biggest kind of confusions, and also, what's public, what's non-public, things like that. So to get started, first of all, let's look a little bit at the sex offender profile. What does a sex offender look like? And the reality is that the research has shown that there's really no sex offender profile. Anybody can be a sex offender. The population is very diverse, it's very complex. It varies in ages. It's across all socioeconomic statuses, all genders. Of course, women tend to have fewer sex offenses, so you won't see as many women that you are dealing with in this population, but you will see that for those who you are working with, who are women, have their pathway to why they committed the crime is much different than maybe those men. So it's very hard to just kind of pinpoint a particular area or a particular demographic for a sex offender. It's very diverse. So I just kind of wanted to throw that out there because I know that sometimes it's like, oh yeah, all sex offenders follow this particular profile or whatever, and the research has suggested that there's really no profile for that. So we're gonna get into the sex offender registry. That is under the statute MCL 28.722. If you go into the Michigan legislature and you type in that statute, it'll give you the whole statute for the sex offender registration. Very informative if that's something that you want to look into. So the way that our registration is set up right now is there are 3 different tiers that offenders can be placed on depending on what their offense was. The first, the tier 1, this is your lowest tier. This is a 15-year registration period, and it has annual verification. So every year, at the month of their birthday, the offender would have to go and verify their information with the local law enforcement office. Some of the tier 1 offenses are not displayed on the public site, so those would only be visible to law enforcement or anyone who has access to the actual system. A lot of your maybe first-time offenders, CSE 4th degrees, depending on the variables, may fall under this category. So it's helpful for them because it's not public, but if a background check is ran, it will show up in a background check. And then this tier also includes registration that a court order for a not listed offense. So there are times where an offense maybe included a sexual element to it, or maybe it was against a child, and the judge orders this particular person to register. So even though it's not a registrable offense under the law or under the statute, if the judge orders it, MSP would have to register them. And so they would be classified as a tier 1 offender, and it's usually non-public. For the tier 2 offenders, this is your 25-year registration period, biannual verification, and this is published. And I will get a little bit into what offenses would fall under what, but this is like your mid-level tiering. And then that's your tier 3 offender. Is your lifetime registration offender, quarterly verification for this. It is published. A lot of your offenses against minors, any offense that's under a child of 13 will be as a tier 3, regardless of if it's a CSE 4th or anything like that. Also, if you have been convicted and registered as a tier 1 offender, and you end up getting another conviction for another sex offense, your tiering is going to be bumped up as well. Any questions so far on any of that? Or any concerns?
I'm not seeing any raised hands or anything new in the Q&A right now.
Yeah, and I can't see anything. I can just see myself and the panelists, so I can't see if other people are being visible.
Okay, I'll let you know.
Okay, thank you.
Yeah.
All right, so some of the definitions for what we're talking about, the first degree criminal sexual conduct here in Michigan, our CSCs are, so there's a lot of offenses that could be registrable. Your actual criminal sexual conduct offenses, which are like your rapes, your hands-on offenses, those are labeled criminal sexual conduct, and there's 4 different degrees for them. So for first degree criminal sexual conduct, the MCL is 750-520B. These offenses include an element of sexual penetration. It could be oral, vaginal, or anally. The victim is under 13 years old. That automatically makes it a first degree. Also, if the victim is over the age of 13, but they're part of the same household or they're blood related, so some of your incest cases, if they are in a position of authority over the victim, if they are substitute teachers or any administrators at a public school, that applies. If there's a use of a weapon, or if it's during the commission of another felony, that's gonna bump it up to a first degree. But the biggest thing with this is that penetration is an element of that offense. So that will automatically kind of raise up the ante on these cases. And of course, the statute does have a lot of other information that would, bump it up, but these are like the major key points for this offense. For those who are sent to prison on a first degree criminal sexual conduct, first degree, they also, when they are released from prison, they have to abide by lifetime electronic monitoring. If that offense happened after, I think it's August 24th of 2006, I think it's the cutoff. I'd have to review it exactly, but there is a lifetime electronic monitoring component for those offenses. So some of the penalties for it, which I kind of covered the lifetime electronic monitoring already, it can be up to life in prison, a minimum of 25 years. If the victim is under 13 and the perpetrator is 17 years or older. And then, of course, a registration as a tier 3 offender, which is a lifetime registration with quarterly verification, and it's public. For the second degree criminal sexual conduct, that's MCL 750-520C, it's sexual contact. If the victim is under age 13 and there's any sexual contact, it's a CSC 13, CSC second, sorry. If they are over the age of 13, but under the age of 16, and they're part of the same household, they're blood related, position of authority of their teacher or substitute teacher. Anybody who works for the Department of Corrections or any volunteer or contractor who is engaged in any sexual contact with an inmate or a probationer or parolee could be charged with a CSC second degree. That's just what the law falls for us. Excuse me. And I see that there's a couple of things on the Q&A. Allison, are there any questions? I see the Q&A highlighted. So I could probably pull it up. Let's see. So the question that we have coming in, our clients who have sex offenses typically face the most significant barriers and challenges of all participants of, oh, okay. I'm sorry, I guess that's part of the introduction. I thought it was a question.
Nope, no new questions have come in.
All right, sorry.
No worries.
Okay. Also with the CSC second, the second degree, that's gonna get into the penalties. It is up to 15 years in prison. Also, the lifetime electronic monitoring does apply as well if they go to prison and then they get paroled. Or if they, because it is a probationary offense, if the offender gets probation, they wouldn't have to do the lifetime electronic monitoring, but if their probation gets revoked and they get sent to prison and then they parole, they would have to do the lifetime electronic monitoring. But it has to be charged as a CSC second degree victim under 13 and individual 17 and over. Like that has to be part of the conviction in order for lifetime electronic monitoring to apply. Now, while they are on supervision, they will be on electronic monitoring for a period of time, depending on risk levels. And I'll get into that a little bit later on. But so if you are working with somebody who's fresh out of prison or freshly convicted of one of these offenses, freshly sentenced, you will still have to deal with some of the electronic monitoring components, but it won't be the lifetime. And then, of course, they have to be on the sex offender registry as well. They are a tier 3 if the victim is under 13. And if the victim is over 13 or an adult, then they're a tier 2 offender. And remember, penetration is not an element of this offense. It's just any contact. And contact is usually defined as any contact of for sexual gratification purposes of any you know, like the breast, the buttocks, vaginal area, like groin area. But it has to meet that, you know, sexual gratification component of it. So the third degree criminal sexual conduct, or MCL 75520D, you will probably see a lot of our younger offenders being charged with the CSC third. It does include sexual penetration as an element of the offense. And the victim is usually between the ages of 13 and 16. It also includes when the penetration is accomplished by force or coercion, or if the victim is mentally incapable, mentally incapacitated, or physically helpless, and the actor knows or has reason to know. So if you have somebody who sexually assaults, you know, somebody who is under, you know, passed out drunk, they could be charged with, you know, under CSC third. If the victim is between 16 and 18 years of age and a student, and the perpetrator is a teacher, administrator, employee, or contractor, it can be a CSC third. So even though the age of consent in Michigan is 16, it does not apply for engaging in sexual behavior with somebody who is in a position of authority over you. So that still would be, that's where you get a lot of your teacher-student relationships. Or also the victim is between 16 and 26 and receiving special education services. A lot of your Romeo and Juliet cases or consent clause cases get charged as CSC third degrees because of those age, the age factor in the offense. So the penalties for this is up to 15 years in prison as well. It's not supposed to be a probationary offense, but you do see some judges giving probation for a CSC third. Sex offender registration as a tier 3 offender. And for CSC third degree, it is subject to the consent clause. So if there was consensual sex acts between a victim who is 13 to 16 and the offender is no more than 4 years older, they could qualify for the consent clause. It has to be specified at sentencing by the judge that they are awarding the consent clause. And that 4 year or older, that 4 year age difference is to the date. So it can't be like 4 years and 1 month, then they wouldn't qualify. It would have to be like right at the 4 year, no more.
We did have 2 questions that have come in.
Actually, let me pull it up. Let's see if I can read them.
The first one is, what percentage of offenders serve their full sentence?
I cannot give you that specific number. I couldn't give you the percentage. 25 years. It just, so for the CSC first degrees, they have to do a minimum of 25 years before they are eligible for parole. So that would be, they probably would have to do that, the 25 years for all of those who are convicted of that CSC first degree, if that makes sense. But I don't have the percentage numbers. I could probably make a note of it and see if I can find that information. And then,
The second one is the question about that you used to be able to see the tiers.
yep, so I actually just talked to Allison about this. Yes, it was removed from the public site. What I would suggest is, because I actually was just talking to somebody who from Offender Success about this, because of releases of information and stuff, we cannot openly disclose that information. I don't think MSP can either. What I would suggest is, if you have an offender that you're working with and they do have to verify, when they go to verify, they get a copy of their document and the tier is right on the document. So you can get it from them. If they don't have the paperwork, if they are on supervision, I would suggest working closely with the supervising agent, because then they can have them sign the appropriate releases of information, and then they should be able to give you the tiering placement. I am not sure why it was removed from the public site. That is something that MSP did. And I actually just became aware of that Friday. So that would be the way to go through if it's somebody who is on supervision. If somebody's not on supervision, then I would just make sure to see, make sure that they keep their paperwork when they go to update the registration, because the tiering will be listed on it. All right, so the 4th degree criminal sexual conduct, that's MCL 750-520E. It includes sexual contact. Again, the victim is between the ages of 13 and 16, and the actor is 5 or more years older. If the victim is under 13 and they end up charging it as a 4th, that still becomes a tier 3 offense, even though CSC 4th is usually just a tier 1 offense. To accomplish the sexual contact by force, coercion usually is an element of it, or if the victim is mentally incapable, mentally incapacitated, or physically helpless, and the actor knows or has reason to know. A CSC 4th degree is actually a high court misdemeanor, but we treat it as a felony. A high court misdemeanor basically means that it's punishable by incarceration up to 2 years instead of the standard 1 year for misdemeanors. We treat it as a felony. It's considered, we count it and score it as a felony when we're doing guidelines. And in terms of supervision, it is supervised as a felony, and it's usually supervised by felony courts. Any questions on the 4 degrees? So the penalties for the CSC 4th is up to 2 years incarceration, and then also registration as a sex offender. It's a tier 1 if the victim is an adult. It's a tier 2 if the victim is 13 to 17, and then it's a tier 3 offense if the victim is under the age of 13. Tier 1 offenses are not published on the SOR side as long as it's only 1 conviction. So if they have multiple counts of a CSC 4th, even if it's an adult victim, because it's multiple counts, then it would be publishable. So some of the other common offenses that you might see on the register, accosting, enticing, or a minor, accosting, enticing, or soliciting children for immoral purposes, that's registrable. Child sexually abusive material, that's what you would hear, people refer to as child porn. We don't really refer to it as child porn because porn has that, it has that connotation that there's some legality to porn. A lot of people engaging in producing pornography are willing participants, and children are not able to consent to that. So it is abusive. So we refer to it as child sexually abusive material, and that is how it's charged as well. That includes the production, financing, distributing, promoting, and possession. Indecent exposure by a sexually delinquent person. So a regular indecent exposure is not registrable, but if it is charged as exposure by a delinquent person, it is. And then an aggravated indecent exposure is registrable if the victim is a minor. Engaging the services of prostitution, pandering, human trafficking, assault with intent to commit CSC involving sexual penetration, and assault with intent to commit CSC in the second degree. A lot of people get this charge confused with a CSC second. They're not the same thing. One is an assault, the other one's a full CSC, but they are registrable. So for the following offenses, though, you do have to have a minor victim for them to become to be registrable. The first one is sodomy. It's only registrable with a minor victim. Aggravated indecent exposure, gross indecency between males, gross indecency between females, kidnapping and unlawful imprisonment. There is a exception for parental kidnapping, but if it's a kidnapping charge with a minor victim, it is registrable. And then soliciting, accosting a minor to commit prostitution or an immoral act. And then serving or distribution of an unclothed person is also a registrable offense. And I do see that there is a question, so. Okay, working with a client who was recently housed with RITHA voucher. He's been denied due to a CSC. I've been advocating for him, have been told there's a clause or law change that may be in his favor. Prisoner probation parole, 1985 photos. Okay. So it sounds like maybe he was registered as part of the retroactive registration. Is that correct? If you want to unmute yourself, Emily, that would probably be easier. Was his conviction in 1983? And then he was in prison in 1995, and that's why he got registered, correct?
Emily, you have the ability to talk if you'd like to.
I'm trying. Did that work?
Yep, I can hear you.
Okay, sorry. I'm on my phone because I'm out working in the field still, but I really wanted to attend this meeting because of this reason and hope to get some direction.
Okay.
I'm sorry, I was trying to unmute myself while you were asking the question.
So it sounds like his offense happened in 1983 and he was in custody in 1995, correct?
That's correct.
And he got registered then in 1995 when registration came into effect.
I'm assuming so, yes. And I don't know. I know that he does go and report at the Michigan State headquarters every month.
Okay. So he can probably get his proof of incarceration from the Department of Corrections.
Okay.
So he can contact, if he was ever in, where does he live?
We're in Genesee County in Flint area.
Okay, so he can probably contact the Genesee County parole office and just ask that he needs proof of his incarceration, and they should be able to give him a printout of what his incarceration and jurisdiction movements was.
Okay, and I don't really understand what this does to help him. Is there some sort of like clause then that would make him eligible then to have the permanent housing?
I don't know if there's a clause, but what I'm thinking could help him is that his offense happened prior to registration being put in place. And
Correct.
then he was just registered because he was actually in custody at the time, so he was still under jurisdiction.
Okay.
What it could do is it could help, because if he hasn't had a CSC after that, like he's been CSC free for a long period of time, so it might just help him to show that he's not, maybe a threat.
Yeah, that's what she's asking for at MSHDA, to try to overturn that, because I requested an informal review for him and we were denied. And then I reached back out and asked her, what else can I do? Because this is so unfortunate. He did like 49 years and, he's out now and he's doing very well and compliant with services and doing great in his new apartment. And I just hate for that to all be over when the rapid rehousing ends. So I appreciate your help. I will reach out then to the parole office here in our county and see if they'd be willing, maybe I'll take him with me, and get that documentation and try to send it to Mishta.
Yep, and it looks like Miriam might have something else from the housing part of it.
Okay,
Yeah, I'm not totally sure on this, Emily, but I do know that Housing Choice Vouchers, HUD prohibits anybody with a lifetime sex offender registry requirement from getting a Housing Choice Voucher. I'm not
Yes.
sure if that's the same with the Rapid Rehousing Voucher. So probably what Mr. is trying to do is determine if he has a lifetime registry requirement.
yeah, he got the rapid rehousing because
If he
they
does
don't. like,
not,
have- Oh, I'm sorry. He does, he's already on a rapid rehousing voucher. This was the denial for through HUD, for the permanent housing voucher. And
Okay.
so, and the woman I'm speaking with there at Mishta said there's some sort of a loophole, like we were just discussing, based on whether he was still, if he was sentenced and convicted prior to this law change or something. And she was willing to go, be above and beyond a little bit and look into that for me if I could just figure out what kind of paperwork she needed. So that's where we're at with what I'm trying to do right now.
gotcha. Yep, hopefully he can keep his voucher.
Yes, me too. I'm concerned, and he's doing so well. So I appreciate your help. Thank you very much.
You're welcome. And then the other question that we have here is, how long is the registry for 750 520 D1A offender crime committed in 1999? So 750 520 D1A is part of a criminal sexual third degree. So that is a lifetime registration. It's a tier 3 offense. So I am not familiar of any anything that would make it less than that. So because it is a CSC third degree, it is a tier 3. Okay. Righty. So some of the challenges that we have, that we see while on supervision with the sex offenders, faced by sex offenders, it's, well, housing, obviously you guys are all here, housing is a huge issue. With the removal of student safety zones recently for parolees and for anybody who's not under supervision, that is kind of getting a little bit easier just because it's not limiting where they can't reside. But when the 1.6 is in place, where it's imposed, the student safety zone 1.6 is the condition for probation parole. When that is in place, it is a lot harder for them to find housing. They also struggle with social supports because they tend to lose a lot of maybe if they had friends or family or something, sometimes the offense that they committed, depending on how egregious it is, like it might have their social supports, kind of detach a little bit from them. The registration requirements, a lot of offenders have a hard time just keeping up with what's required of them and what they have to register and what the deadlines are. There's a lot of nuances to the registration, depending on when the offense was committed and how long they have to report changes. And so that sometimes, especially if they're very busy and they're following up with all their other requirements, it's easy for them to forget what they have to do for registration. Employment is difficult. Some people don't want the liability of having a registered sex offender working for them. And also because they have to register their employment with MSP, and it is a public registry, depending on their offense, a lot of employers don't want that. So that kind of limits their options for employment. And then in general, it's just a stigmatized population. They're walking around with that scarlet letter. And so it's just very difficult for them to get acclimated. There's also a lot of personal shame that goes with being convicted of a sex offense. So that also kind of adds on to some of those struggles and some of those challenges.
We have another question.
Yep, I see
Yes.
that.
Okay.
So for more info on pre-registration convictions and registration, you can check The Doe's lawsuit information, ACLU website, a letter from Attorney General, MSP website, help clarify ourselves. I believe with, what do you mean? With the Doe lawsuit, I believe had to do with, the people that were registered, that not retroactive registration, but the changes that came in 2001 and then again in 2011, going back to 1995. Is that what you're talking about, John?
John, I'll give you permission to speak as well. That sounds terrible. I'll allow Zoom to let you speak.
Can you all hear me?
Yep.
All right. Yeah, I believe that some of the things that came out of the Doe's lawsuit were applicable to everyone that had been on the registry prior to the lawsuit, and then some of it only applies to folks that were registered under the old scheme and then changing into the new scheme. So there's a lot of stuff on the Michigan ACLU website. Some of it's legalese, so you might be better served by looking at what Attorney General Nessel sent to MSP about who they are and are not able to consider registered sex offenders and place on the registry.
Yeah, so I know the Doe versus Snyder, there was a lot of issues with the rules that became applicable in 2011 being applied to those people who convicted their offense prior to that. And so they had to make some changes. So going back to like some of the challenges that our offenders face in keeping up with the registration changes, that has, some offenders have to register like their phone number and their internet and all that stuff because their offense happened after a certain time, whereas other offenders don't have to do that because it happened prior to that time. But before the lawsuit, everybody was being required to do that. So then that lawsuit kind of said, no, it's not fair that you are applying these restrictions to people who committed the crime prior to this happening. So that is one of the things that came out with that, but thank you for putting that information in there. It is kind of important to know because when the offense and the conviction happen does affect what needs to be registered, if that makes sense. And yes, Jennifer, I'm sorry, supervision does mean probation or parole. So when I say they're under supervision, it means that they're under the jurisdiction of the Department of Corrections. Okay, so, all right, so some of the additional challenges that for those who are on community supervision, so probation and parole, there's contact restrictions. We have the authority to restrict any contact with minors or with particular people, particular victim pools, for example. If somebody has an offense that included a minor victim, we can restrict contact with all minors without any exceptions. Or we could also allow contact with certain minors after they go through a rigorous process. So that is one of the things that while they are on supervision, we have the authority of doing that. We can also impose computer restrictions, mostly internet use and the use of social media. All of our offenders who have the computer restrictions have to sign an agreement before being granted computer use, and they are subject to monitor. They also, because if they have internet use or computer use, they are still very restricted as to what sites they can go to. They're not allowed to be on social media. And we do monitor those devices and that usage pretty routinely. We also can impose location restrictions like schools, parks, video games, arcades. With the removal of student safety zones, we are not, we are not enforcing law, but we can still enforce conditions of supervision if the preferred victim pool is a minor child. So going to the safety zones, the student safety zones were first introduced in 2006, but effective March 24th of 2021, they were eliminated from SORA. So the student safety zones no longer apply to the parole population unless they are mandated as a special condition by the parole board. And it would still not be imposed as a statutory issue. It would be more of like, you could not be, you know, in school property, or it has to be a lot more specific. It can't just be, you can't be within 1,000 feet of a student safety zone, because one of the issues with the lawsuit is, well, what is 1,000 feet and what is a student safety zone? And so there was a lot of questions with that. Now, student safety zones still do apply to probationers under Public Act 397 of 2020. So when they reviewed the whole statute and the whole like legal part of the student safety zones, they didn't really look at this Public Act, which says that as a condition of probation, student safety zones apply. However, they have to be ordered by the judge. So when a probation agent is doing the recommendations, we have to recommend student safety zones being in place because that's what the Public Act tells us to do. But we can only enforce it if the judge orders it. So if the judge doesn't order it, then we don't have to abide by student safety zones. And then the PA 397 of 2020, like it said, just requires the court sentence a probationer convicted of a listed offense to a 5-year term of probation, and still requires that the court orders the individual not to reside in the student safety zone, work in a student safety zone, or loiter in a student safety zone unless they meet the statutory exemption. But like I said, it has to be court ordered. We cannot enforce it otherwise. If you are just working with people who are on parole or people who are not on supervision at all, then student safety zones are no longer an issue for them.
We do have a question.
Mhm.
Says, are lifetime offenders restricted with their own children, granted the offense does not involve their own children or any incest?
So the child restrictions are only while they are on probation or parole, not while they are, you know, once they're off supervision, those are not being enforced or monitored anymore. And that depends. If there's 2 conditions that we can impose while they're on supervision, we can impose condition 1.0, which is no contact with any minor under 17 whatsoever. And then there's condition 1.2, which is no contact with a minor unless you have been given approval and you are with an adult responsible for that child. So if the offense did not involve a child and the preferred victim pool is not, you know, they're not considered to be a threat to that particular age group, we can still grant access to them. We could also make an exception where they cannot have any contact with any children except their own. So it's a case by case basis. You have to look at each case. You can't just, I can't give you an answer just in general because it's going to determine on, it's going to vary on the elements of their case, if that makes sense. So all of those cases are monitored very closely when it comes to the contact restrictions. But like I said, once they're off probation and parole, those restrictions are not in place anymore. Are lifetime offenders not on supervision still exempted for student safety zones? Yes, so the student safety zone is basically no longer in the books. It went away, it's not, it can't be enforced anymore. All right, so some of the common supervision conditions, and this is kind of something that I've already touched on a little bit. So no contact with minors or approval required for minor contact. And when we are looking into granting approval, there are assessments that we can request our treatment providers to do to see if somebody would be a threat to a particular child. There's also classes that people who would be monitoring or chaperoning that contact can go through to make sure that they know what to look for and what to be aware of. We also staff the cases with the agent, the treatment providers, supervisors, to see if it would be beneficial to granting access to that contact. Some of the other conditions that they may not reside with or care for a minor or date anybody who has minor children. Residing, working, or loitering within the 1,000 feet from a school or 500 feet from parks, playgrounds, municipal pools, or child care centers. And those are cases that when we receive the pre-parole or when we're doing the pre-sentence investigation, it's going to depend on their victim pool, the elements of the offense. So if it happened at a park or an area where children usually congregate, then we are going to be more likely to put in this condition, but we're not just going to do a blanket condition for that anymore. May not use or possess sexually stimulating material. The condition does say as dictated by the treatment plan. This is one that we are currently looking into because sexually stimulating material is a very vague term. Usually you think maybe pornography or sex toys or something like that. But if you have somebody who has a shoe fetish, JCPenney shoe catalog might be sexually stimulating. So we have to really be aware of what people's interests are for us to define what is sexually stimulating for them. So it is one that we are looking a little bit closer at. All of our offenders who commit a sex offense, we are recommending or ordered sex offender programming, whether it's in the prison or in the community. For those who have child victims and child like contact restrictions, they can't have any children's clothing or toys or games. For those who have CSAM offenses, we may, or serving offenses, we're going to prevent them from having any kind of photographic equipment. They're subject to polygraph as for parolees, they all are subject to polygraph. For probationers, it does have to be ordered by the judge before we can do one. Like I said, we have the computer conditions and the internet conditions, limits on social media, and we may prevent, entering exotic dancing establishments or any other place like that. Those are just some of the conditions that you might see on somebody who's serving on a sexual offense.
We had another question come in.
Mhm.
Are lifetime offenders not on supervision still exempted from the SSZ's rule?
Yep, I did answer that. We forgot to delete it, but yes, they are exempt from it. There's student safety zones are not applicable for anybody anymore unless there's a probationer that was ordered by the court to have it. So basically, if you are looking for housing, you don't have to worry about proximity to a school anymore, because it's not being enforced and it's not in the law anymore.
And another one just came in. When it comes to social media, LinkedIn is considered a social media, but also very helpful for job search. Are they unable to utilize this?
That is a case-by-case basis. The blanket answer is yes, it's still considered social media. Any platform where you can communicate with other people and kind of have that direct messaging with other people, that's something that we would closely monitor. So it is one that we could approve subject to monitoring, but it's going to depend on every case, if that answers it. So any other questions? That's pretty much what I have. I kept it pretty basic in terms of what you might see just in general. Not every case is going to be the same. You're going to have cases that you're going to be like, I don't know what to do with this guy. So if there are specific questions about specific cases, we could definitely try to hash those out. Or if there's any other questions that maybe I didn't cover that you're interested in finding out, please let me know. Yes, Dorothy, that is correct. So if they are a parolee or if they are not on supervision, student safety zones are not applicable anymore. That was removed from the law in March of 2021. So are there any other questions or?
We have a question that I think leads into our next segment really well, which is, are there any resources that assist offenders with low-income housing or housing in general? And then we have another one that might be for you that says, when it comes to photographic equipment, what about cell phone ownership? Most cell phones are equipped with cameras, so would they not be able to have one?
So if they are able to find one without a camera, that's what would be preferred. Right now, it's almost impossible to do that. And it's almost more expensive to get one without a camera. But if they do get one with a camera, they have to be able to disable the camera. So there's gotta be ways of disabling the camera, whether it's doing something with the settings or breaking the camera. I mean, we've seen people actually, and it's people are gonna cringe because these phones are pretty expensive, but we've seen people put a nail through the camera of the phone just so they could keep their phone. So they are not going to be able to keep it. They have to be able to disable it. Now, it is being a little bit more lax these days because of COVID, and we had to do a lot of supervision via video and via phone and stuff. So we can kind of modify it a little bit. The nice thing about some of these conditions is that agents do have discretion. And so we can modify those conditions to kind of fit the need of the offender and the supervision needs. But yes, if usually we have to be able to figure out a way of disabling that camera.
And then one more came in. Are there any peer support groups to your knowledge for this population?
Yeah, so there is a sex offender anonymous group, like not sex offender, but there's a Sex Addicts Anonymous. Also, some of the treatment groups, if there were somebody who was ordered to do treatment as part of their supervision, once they're done with programming, they actually have like monthly support groups that they can still attend. I believe that there's some faith-based like Celebrate Recovery that touch on sexual issues as well. I think Sex Addicts Anonymous follows more of a 12-step, and then Celebrate Recovery, I think it kind of follows along that line, but it's not formal. I don't know of any formal support groups aside from those provided by the treatment providers that, like just aftercare for their treatment group, if that makes sense.
And then another camera question. Can any sex offender have cameras installed onto their house or have surveillance cameras like a Ring doorbell?
Yeah, that if it's not, there's nothing in the law saying they can't have that. So the only time that this would be an issue is if they are on supervision, then Department of Corrections can monitor and can restrict that. But once they're off supervision or they've not in supervision, it's not something that MSB is enforcing for the convictions.
Okay, well, if you
Oh,
have
really
any
good
questions,
question.
please keep them coming. But again, the question that was asked a few minutes ago is a great segue to our next section, which is asking about housing and ex-offenders.
All right, well, thank you so much, Miriam. I'm going to stop sharing so you can share yours.
Okay, sounds good. All right. Nayat or Allison, can you let me know if you just see the slide to make sure
It's
I share
perfect.
Yep.
correctly? All
Yep, we
right.
can see it.
Thank you. So good afternoon, everyone. I'm glad to be here, even though it's a difficult topic to speak on. I think it's important to have these conversations and share information. My name is Mariam, and I work for Department of Corrections in our Offender Success Program that we call OS, as we try to transition into using person first language and getting rid of what can be a harmful label of offender. So we're just referring to our program currently as OS. but you may know it as the former names of MPRI, Michigan Prisoner Reentry Initiative, or Prisoner Reentry. So these are all the same program, and like I said, OS is what we're currently calling the program, so that's what I'll refer to it as while we're talking. So OS exclusively works with people under jurisdiction of Michigan Department of Corrections who are referred for services by their agent. The program works with people on parole or those on probation who went through MDOC boot camp. There's a few small populations who are included in that, but generally the services that I'm going to talk about are available to people who are on parole. So they're currently on parole from a Michigan Department of Correction facility. That does not include people who may have come out of county jails unless they're also on parole from an MDOC facility. It also does not include people who are on federal parole or probation, so who came out of a federal prison. When we talk about people who are justice involved, that can be a huge population. So I just want to be really clear that the services we provide are primarily to people on parole from MDOC or a few other smaller populations. I know we have some OS staff on the call, so happy to see you here, and feel free to speak up in the Q&A if you have anything to add to what I say.
Hey, Miriam,
Yeah.
just quick question, and I just want to throw that out there because I know we get that a lot, but does everybody know the difference between probation and parole?
Good question. Let's not assume that, and let's go ahead. Do you want to speak to that, or do you want me to?
Well, I mean, you can if you want to. I just didn't know if I just want to make sure because I know it's not all corrections people here, so I just want to make sure that people knew the difference. But yeah, I guess I can go into it. And I'm very sorry to interrupt, but it just came to my brain that this was an issue. So people who are on probation are actually, even though they're supervised by MDOC, they're still under the jurisdiction of the court. These are people that get sentenced to jail or to probation only. They never go to prison. And so they don't, they are just on that probationary period. People who are on parole are people who have actually gone to prison and then they get released under supervision, and they are supervised by parole agents from the Department of Corrections. And so the jurisdiction falls on the parole board, whereas for probationers, the jurisdiction falls on the courts.
Thank you so much. I think that's really important. I'm glad you said that. OS provides 4 different types of services. We provide residential stability, job placement, social support services, and health and behavioral health services. We follow the state's prosperity regions in the way that our program is divided up. If you look at this map of the state of Michigan, Michigan's divided into 10 prosperity regions. Each of those regions has an agency that's contracted to administer the program in that region. So depending on where you are in the state, you can see which region you'd fall under, and then you'll also see a directory of the staff from that region. If you're not already connected to your staff in that region, I think that would be a great takeaway from this meeting today if you want to get incorporated to what's going on with OS in your community. We offer 2 types of housing. Either when people are getting ready to leave prison and they don't have a place to leave when they parole out of prison, or if during their parole they become homeless and need a place to stay, they can get temporary housing in OS funded housing. So the funds come from Department of Corrections to our contracted agencies in the community, and our contracted agencies turn around and subcontract with housing providers. So a 24/7 structured facility might be a facility that typically does substance abuse treatment or provides homeless services in a formal setting that includes 24/7 staffing. Or the majority of our housing is just apartments or hotels or houses that are rented by our contractors so that people who are experiencing homelessness can be placed into those locations temporarily. Some of the limitations of our housing. I mean, what's cool about our housing, and I'm going to talk about in a minute, is that we hopefully lift some of the burden from homeless service providers by doing some planning for people who are under parole supervision. But it's not a permanent solution. It's temporary in nature. Our goal and our guideline is currently to have people in housing up to 90 days. Now, some people get out on their own much sooner and some people stay much longer. But overall, a limitation of it is that it's temporary. So we still are looking for a solution for people to have permanent housing. Another limitation is that it sometimes feels like an extension of prison. People have to abide by the housing rules, whereas if somebody paroles with family or if they're able to get their own apartment or their own house, they only have to follow their regular parole rules. But if they're in an OS funded house, they have extra restrictions. Another limitation is that we take the housing that we can find, and with the housing shortage, we try not to, we do have some practices in place to make sure that our housing is up to par. We expect of our housing contractors that they inspect each property every 90 days. We have a formal subcontracting process where each subcontract has to be approved. And we may work with hotels and motels that are accountable to local standards and rental standards. However, housing is limited, and this is can be a difficult population to find housing for. And just to be clear, we are talking about anybody who's on parole, not just people with a CSC, but I'm in this conversation giving a particular emphasis to people with a CSC conviction. Another limitation is that people in our housing don't typically have their own transportation. We look for housing that's on bus lines or within a taxi service. But as you know, a huge portion of our state does not have public transportation. So most people are at the mercy of the rides that they can find or what we can provide. And the last limitation, like I spoke to, the fact that it's temporary, is that it can be really difficult to find permanent housing solutions, especially for people with a CSC. I'm preaching to the choir right now. You are the people in the community looking for those permanent solutions. So just noting that as a limitation. So how we find our housing and how we look for long-term solutions, we have a regional recruitment approach, which might include cold calling landlords and property managers, word of mouth communication and referrals, websites like showmetherent.com, or our contractors might put out a request for proposals looking for landlords or property managers who would want to rent to our program. In terms of our monthly payment, we use the HUD fair market rate as our guideline of what we should pay. And we may make exceptions based on extenuating circumstances, but we use that as a guideline. There's some benefits to landlords of working with OS. They get a consistent monthly payment. They don't have to follow the eviction process because our program is moving people in and out of the house. If there is somebody not following housing conditions, typically that is addressed by OS staff and or their parole agent. And the other benefit to the landlord is that the person is under that extra oversight of parole and OS and receiving supportive services. So that may alleviate some of the problems that would have come up with a typical landlord-tenant relationship. We do encounter some difficulties, although we don't see a high rate of damage to houses that we rent. There have been some awful situations, such as people starting a fire in the unit, smoking, clogging toilets. We've seen some significant damage. We do collect incident reports and track serious incidents in housing, so it does happen. However, when we look at the numbers, we have found that the perception that landlords and even some of our staff have, and even some of us, are biased in thinking that people on parole are a more dangerous population to supervise, doesn't pan out in the number of incidents that we track from our office. However, we don't want to lie or deceive any landlords. We want to be upfront and acknowledge that there is a potential that people will damage units. We do get we're probably more likely to have bed bugs in housing because of people moving in and out and our transient population. And that is something that we need to disclose to landlords when we work with them.
We have two questions.
Yep.
One is, do you pay rental damages? And the second one is it common to place people in adult foster care homes when apartments are not available? I heard this was a practice in some rural areas, causing concern for other residents of the AFCs.
Two good questions. So the first one, in our subcontracts are between our contractor in the community that administers the program and a local landlord or property manager. We, as MDOC, require that subcontract contain a clause that the landlord needs to maintain liability insurance that would cover damage to the apartment. So in general, MDOC does not cover damage to apartments. For the most part, we have not found that to be a barrier. Once landlords start working with us and they realize that, in most cases, they realize that the benefits outweigh the risks. There have been some incidents of extensive damage, and we have made some exceptions to assist with covering the cost. The second question about placing adults in AFC homes, one thing I'm not speaking to in this presentation is that there is a special program within the Department of Corrections through a contract with Professional Counseling Services, where people who have an intense need for mental health supports due to a serious and persistent mental illness that impairs their daily functioning, or a very serious medical condition, they get services instead of through OS, they get services under a special contract with Professional Counseling Services, which covers the entire state of Michigan, and they find placements for people that are under their contract. So typically those are going to be people who would qualify for adult foster care in the community. And they may get placed in apartments just like OS participants might, but they would be much more likely to be placed in an adult foster care home. Again, they're not being placed there because they shouldn't be placed there because there aren't other options. They should be placed there because it's in the best interest of the client, and that's the appropriate level of care. However, yes, that could bring up concerns for the community and for the people that they live with. So I hope that answers the question. Feel free to ask follow-up questions. Lastly, I just wanted to highlight the challenge of the lack of housing, as you know, in rural areas or in high demand areas like Grand Rapids and Ann Arbor, where housing is already expensive. Another huge challenge that we are working on is that large property management companies often outsource their application process and have a blanket ban on people who have a criminal conviction of any kind, or they may have a large look back period, which is excluding people that we think would be good tenants, or we think would be no different than any other tenant. And they're being excluded simply because criminal conviction is not a protected class when it comes to rentals. However, race is a protected class, and several years ago, you may be familiar with a memo that was put out by HUD stating that landlords who have a blanket ban on not renting to people with a criminal conviction, although criminal conviction is not a protected class, race is a protected class, and we do know that there's racial disparity in our justice system. People of color are disproportionately represented in the justice system. Therefore, HUD advised through a memo that landlords who have a blanket ban on renting to people with a criminal conviction may also be inadvertently violating the rights of a protected class by race. So,
We had another question.
yeah, go ahead.
Not sure if you would know this, but it says, are there AFC homes that take sex offenders?
Yes. Yep, there are. I don't know what goes into that. I don't know if it's up to the discretion of the AFC home or if they are allowed to come up with that. I don't know.
So can I jump in?
Yes, please.
So usually, so usually some of the AFC homes will actually have homes that are either specific for that population and they will put all that population in one home. Um, and it's something that that contracted PCS contract, usually the person working is able to identify those homes. And then when they go in to find a place, they will tell the manager of the home, like, you know, what the conviction is and stuff and see if they will place it. So they can still deny certain ones. Like if you have a very violent offender or a very high risk offender, they could still deny it. But usually they're upfront with the managers and they will take it. So they're somewhat limited, and they usually try to house all of that population within one same house.
Super helpful. Thank you for unmuting for that. To the question of whether OS base housing poses an increased risk to public safety. This is not specific to sex offenders, but just in terms of speaking to landlords and property management companies, and even to ourselves and our internal team, dealing with the perception that this is a more difficult population to house. We did a survey to see whether that was true. We only looked at 1 year in this particular survey, but we asked how many people had been removed from our housing due to a few different types of very serious circumstances, including threatening behavior to landlords, neighbors, and such. And in the year that we looked at, we had about 2,000 people housed at 200 different locations, and there were no instances reported by our staff or by parole in which OS removed people from base housing for threats of violence to landlords or neighbors. We did have 14 incidents where people were exited from housing due to property damage, and that was less than 1% of the total people that were housed. We do continue to receive ongoing incident reports, so we do know when there are serious incidents in housing, and serious incidents do occur. But we think that these numbers speak to the fact that this population is not particularly more problematic, simply due to the fact that they are on parole. We have a very cool partnership with MSHDA. Several years ago, we talked to MSHDA and they offered to do a project-based voucher program with the department. They let us come up with guidelines on how we would prioritize and distribute a set of vouchers that they gave to us within the HUD and MSHDA rules. So if you are familiar with HUD rules, people with a lifetime CSC requirement, registry requirement, are not able to receive a HUD voucher. Our voucher program has been very successful in terms of getting people housed into a permanent solution. And we're looking at, we prioritize people that we think are the highest risk of lifetime homelessness. And we have had very few people who've gotten a voucher have returned to prison. Statewide, around 1 out of 4 people who leave prison go back within 3 years. Within the first 150 vouchers, there's been more by now, but the last numbers that I looked at, only 6 people had gone back to prison. So if we want to look at a way to dramatically reduce the number of people who go back to prison, looking at a very difficult population to work with, we can see that people who get a housing choice voucher are far less likely than the average person on parole to go back to prison. So we're pretty proud of that, but we have this huge barrier when it comes to HUD, prohibiting people with a lifetime CSC requirement from receiving a voucher. We have these vouchers, we can't give them to our most difficult population to house in the long term.
We have a question about that.
Yep.
Is there a way for community partners to refer for HCVs for folks with CSCs and have been denied for HCV in the past? So I'm assuming they're asking, can they refer their clients to your program?
If they don't have a lifetime registry requirement, then yes. The process starts with either their parole agent or your local OS staff. I'll give you a directory of staff at the end. And Allison, I'm not sure if I didn't think about this part, but we could definitely share our staff directory even though we're not sending out the PowerPoint, we could send out the staff directory. That would be really useful for folks who want to get in contact with their program locally.
Is there a link for it? I know that that same map, but for housing is a link on michigan.gov.
Yes, there is, although I don't have it at my fingertips, but it's probably the same link. But I can make sure at the end also.
Susan and I can look for it in the background as
That
well.
would be awesome. We're really looking for the community coordinator list is what it would be called.
Okay.
Thank you. All right, and jump back in if there's more questions because I'm just rolling right along. All right, let's talk numbers. How many people do we actually house? Our housing referrals are currently down because our prison population has reduced. We're proud of the fact that we've been able to safely reduce the prison population and put more of our dollars into rehabilitative services and offender success supports versus keeping people in prison just simply for the fact that we didn't have a way to serve them in the community when they get out. So between April of 2021 and March of 2022, the last year that we measured, about 2,000 people were housed for at least one night in one of our locations. And in total, these people used 200,000 bed days. So that I think speaks to the scope of the need. These are just people who are referred to our program. We're not talking about the entirely justice involved population, but just people on parole who were referred. 200,000 bed days were utilized. The average length of stay at discharge is a little higher than it has been in the past. It's currently 81 days. So we may have people who stay for a year or even longer. They're eligible with extensions. They can potentially be eligible to the end of their paroles. But some people get out in fewer than 81, some more. The average is 81 currently. A trend we're looking at is that we're housing fewer people. Don't read my slide because there's a typo there. We're housing fewer people than the past, but they tend to stay longer in housing. Some people stay much longer. So originally our housing length of stay was 62 days in our fiscal year 21. Preparing for this presentation, I wanted to get an idea of what we anecdotally say that people with a CSC stay in our housing longer, but I wanted to actually get numbers to put behind that. And so I looked at our fiscal year 21, the average length of stay during that year was 62 days. However, during that year, there were 43 people who had been in housing over a year. So at the end of that year, there was 43 people who were still in housing who had been there over a year. So I looked at those 43 people and found that men with a CSC conviction were much more likely to be in OS funded housing for over a year. Why are they in there so long? They either cannot or will not find a permanent solution to housing. The people with the longest length of stay, there were, out of those 43, 39 were male and 4 were female. 31 had a CSC conviction in Michigan, so that's 72%. And if we break that down and just look at the men, because it was in this case all the men that had CSCs, 31 out of 39 of them. So if we look at men who stay in our housing for at least a year, in this case, 79% of them had a CSC conviction. And there is possible that more of them had other convictions from out of state that I didn't see, but at least 79%. So again, that speaks to the problem of the most difficult population for us to find long-term solutions are men with CSC convictions. And I see we have a chat here. Oh, thank you so much for posting that link. And it looked to me like a question, but I don't think it actually is a question. So Allison, just interrupt me if there is a question.
It's not. Jennifer posted it in the Q&As and then I reposted it. So people should be able to see it.
Appreciate it.
If not, it's clearly, I guess it's easy to find because she found it immediately.
That's a new thing. Our website is definitely needed work.
But we do have a question that came in.
Yep.
We currently have 3 participants that have used a lot of days in housing. That is because they are immigrants waiting for work authorization paperwork from the Department of Homeland Security, which can take anyway from 6 to 11 months. Oh, I guess it's just a statement.
Yeah. Emily,
Letter.
we don't know each other, but I think you were one of the people that worked in OS, so that's a good point too. Some of the people who are in housing for a long time have these significant barriers, like waiting for work authorization. So thank you for that. I think everyone on this webinar would agree that people with a CSC conviction need access to stable housing if they're going to live a stable and productive life. But people with a CSC conviction are more likely to struggle to find long-term housing. So that's really my problem statement here, is that, and what I say to the public, we're not talking about a handout for people. We're talking about people who are coming back to the community anyway. They can come back in a way that makes them more stable and prepared to live a stable life, or they can come back to the community unprepared without the things that they need, like the basic need of stable housing. So who do we want living in our communities? I think as a society, we have to ask ourselves, are we shooting ourselves in the foot with rules like prohibiting people with a lifetime sex offender registry from getting a HUD voucher? The intent is probably good, that people with the most need, the most deserving, at least in public perception, are going to be more likely to get a voucher. What it ends up meaning is that people that need it the most are unable to access things like that. So how can you get involved or find out more? OS is governed in each of the 10 regions by a steering team. A steering team is the governing body that makes decisions related to budget and programming. And you may be interested in serving on your local steering team. We also have community-based advisory councils. Each region, some regions have one, some have multiple councils. An advisory council is a citizen body, the voice of the community, who can both hear about what OS is doing in your region and also help solve local problems on a regional level. So if you're interested in serving on an advisory council, we would love to have you. You can also invite your OS community coordinator to speak to your group if you work for a housing provider or a HARA. Hopefully your community coordinator and your HARA are already communicating well. Many of them do. But if you want to talk more about people who are justice involved, specifically the parole population in Michigan, that would be an awesome opportunity for your community coordinator to speak to your group. If you're working personally with a person who's under MDOC parole supervision right now, I highly advise that you talk to the person about communicating with their agent, as you're both case managers of a different portion of the person's life. The parole agent is the case manager from an MDOC perspective. You're a case manager from a housing perspective. So I think it's really important when you can to communicate together and work collaboratively. So I highly recommend that. This is our directory of community coordinators across the state. We have an excellent team of community coordinators who are leading teams of staff, many of whom are on this call. And I thank you for the work that you do. If you may recognize the agency or the person from your community who's the community coordinator. If you don't, I will leave this screen up. You can jot down their number, or you can use the link in the Q&A or in the chat to reach out to them. And I just have my contact information on the last slide, so I'll leave this up for a minute if you want to take a screenshot or write a note of who the person is in your community. I'm going to assume that we have people from all over the state, from the UP down to Monroe.
Correct.
Awesome. So I hope that you, if you're not already involved, if you are, I thank you. If you're not, I encourage you to get involved locally with OS. And also thank you for the work that you do in terms of providing services to forgotten members of society. And it's a difficult job. I really respect and appreciate what you do. And I thank you for your time. And I'm open to taking any more questions. Here's my contact information.
As a reminder, we are not sharing the PowerPoint today. So if you do have questions, please reach out to our speakers. We have a couple more minutes. We can take questions if we have them. If not, I will just do my spiel and then we can end. So I just wanted to once again thank all of our service providers who showed up today to learn more about how to help this population. I know that you are super busy and taking any time out of your day is kind of a big deal, but I do love that we're able to help you with some information so we don't have to rely on our clients to educate us. We can educate each other. So thank you for showing up. I would like to thank our speakers so much for sharing all of their expertise and for taking the time to make this presentation for us and carve out time in their day. So hopefully some folks have create some new partnerships through this webinar and have learned some more information. Sounds like we may have helped a couple specific folks out. So that's really exciting. I just want to remind folks that these webinars are free. There's one free training a month. The one next month is a redo of our SOGI 101, which stands for Sexual Orientation, Gender Identity, and Expression. That will be presented by the Ruth Ellis Center. The recording of it is on our YouTube page. This will be a live presentation of the same material. So if you want to be able to ask questions, or if you're like me and you need to attend things live, it is the next month. Susan's putting the information in the chat. It looks like it also can be found on Micah's website. And I wanted to let folks know that if you enjoy these trainings and they are helpful to you, consider becoming a Micah member, because that is how we're able to provide them to you. So individual membership is $45 a month. Now a year, sorry, it is not a monthly fee. And then organizational membership is on a sliding scale. So with that, thank you all again so much. Let's see, we're having some thank yous come into the Q&A. So again, just want to thank everyone, and the recording will be up on our website in a few months if you want to share it with colleagues. All right, I hope everyone has a fantastic day, and I appreciate all the thank yous that are coming in. So with that, I will end the webinar. Have a good afternoon, everyone. Bye-bye.